You're good.
Right. The Second Amendment, it's not what you think. Charleston, South Carolina, 8 dead, 1 injured. The recent shooting in Charleston made me feel a lot of things. I was angry, I was sad, but mostly I was frustrated. Frustrated because nothing's going to happen. The sad state of our current country and gun control legislation is that nothing changes. We will kick, we will scream, we will be sad over this tragedy, but in a few months we will move on and we will forget about it. Mass shootings are far from the only gun violence problem we have in this country. According to the CDC, in 2013, the last year for which there are records, there were 33,636 firearm deaths in this country. Since 2010, there's been an average of 33,000 gun deaths per year, by far the most of any wealthy nation. Furthermore, this year, according to the Center for American Progress, gun deaths are suspected to surpass car deaths for the first time in our history. It is clear we have a serious gun violence problem, but I'm not here to talk to you about that today. Today I want to talk to you about the #1 argument against gun control and the fallacies of that argument. Today I want to talk about the Second Amendment and the fact that the Second Amendment does not protect individual rights to bear arms. So let's revisit what the Second Amendment says. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So what does that mean? Where's the debate here? The question is really whether this is a collective or an individual right. This is what was the founders intended? Did they intend this to be a collective right for militias, or did they intend this to be an individual right for individuals to carry firearms? Let's first look at what some legal scholars have had to say on the issue. According to Jeffrey Toobin, legal analyst, according to the Supreme Court and the lower courts as well, the amendment conferred to state militias a right to bear arms, but did not give individuals a right to own or carry a weapon, supporting the individual right view, of the collective right view rather. Furthermore, according to a recent study in the Cleveland State Law Review, as late as a decade ago, the federal court's interpretation of the Second Amendment was simple. Every circuit that had ruled upon it had held that it did not guarantee individual rights to arms for individual purpose, whether it reflected some form of a collective right. This is where we were. This was our history. Furthermore, according to the first Supreme Court case to deal with the issue, U.S. v. Miller, the question was, did the Second Amendment protect Miller's right to carry a shotgun? In a unanimous decision, the court ruled, in the absence of any evidence tending to show that possession or use of a shotgun has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to bear and keep such an instrument. U.S. v. Miller supported the Second Amendment, and this was the court's view until 2008. So what changed in 2008? In 2008, the Supreme Court ruled on D.C. v. Heller. In a split decision, 5-4, the court ruled that the Second Amendment conferred an individual right to keep and bear arms. This is where the individual right view comes from. The problem, and this is the problem we have with passing gun control legislation, the problem with D.C. v. Heller is it flies in the face of decades of Supreme Court precedent and the founders' original intent. Let's first look at what the dissent in Heller said. According to Justice John Paul Stevens, the Second Amendment's omission of any statement of purpose related to the right to use firearms for hunting or personal self-defense is especially striking in light of the fact that the Declaration of Rights in Pennsylvania and Vermont did expressly protect such civilian uses at the time. What he's saying is that prior to the Bill of Rights, in Vermont and Pennsylvania, they wrote their version of the Second Amendment to protect individual rights to bear arms, and they explicitly said this. They did not say this in the Bill of Rights. Why would they leave this out if this was the intent, if the intent of the Second Amendment was to protect individual rights? It just doesn't make sense. Furthermore, in Stevens' dissent, the court also overlooks the significance of the way the framer used the phrase, the people, in these constitutional provisions. In the First Amendment, no words define the class of individuals entitled to speak, to publish, or to worship. In that amendment, it is only the right to peacefully assemble and to petition the government for redress of grievance that is described as a right of the people. These rights contemplate collective action. So in the First Amendment, the founders used the phrase the people strictly to refer to collective rights, the right to assemble and the right to petition a government. The individual rights to speak, to publish, and to worship are not given the same treatment of the people. That's because the people is used as a collective term. We collectively have the right to bear arms as a militia. We do not have the individual right like we do to speak, to worship. Why is this so important? Because the individualist view of the Second Amendment, supported by D.C. v. Heller, is preventing sensible gun control legislation and is allowing tragedies like the Charleston, South Carolina shooting to continue. If we can accept the collectivist view, which was the founders' intent, then maybe we can get some sensible gun control legislation passed. I hope I've convinced you today that the Second Amendment does not protect the individual right to bear arms, and that it instead protects the collective rights of a well-regulated militia. Because if we can get away from this individual viewpoint, we might actually see some progress on gun control, and maybe we can prevent 33,000 dead Americans each year. Thank you very much, and thank you to my audience. If you could just state your name.
Dayon Harris.
Eugene Fryer.